Good evening. My name is Bria Lundy, and I attend Florida International University. Today I will present to you a speech on the Florida Stand Your Ground Law. 17 years ago in Springfield, Oregon, a local mechanic went into a fast food restaurant, walked up behind a man eating lunch, and shot him to death in the back of the head. A local grand jury refused to indict the shooter. There had been no altercation, no sign that the man shot was carrying a weapon, but the shooter believed that the victim had threatened his daughter, and the dead man was, in the words of the local district attorney, a violent man, a drug dealer by trade. Maybe the shooter should have left it to the police, the district attorney said, but the victim should also have moderated his behavior. I present this account as the history of the Stand Your Ground Law. Florida statute now states that a person who is not engaged in an unlawful activity and who is attacked in any other place where he or she has a right to be has no duty to retreat and has the right to stand his or her ground and meet force with force, including deadly force, if he or she reasonably believes it is necessary to do so, to prevent death or great bodily harm to himself or herself or another, or to prevent the commission of a forcible felony. I am not a lawyer. I am not even a criminal justice major, but simple research and a bulk of common sense has allowed me to see that an immense percentage of homicides include some claims of self-defense. He had a gun, he hit me first, or maybe he just looked at me funny. Under this statute, defendants can present those claims before trial in a motion on the basis of immunity. And if that is denied, they may also try to provide self-defense at trial. In layman's terms, no longer does someone invoking self-defense need to show clean hands, even if, in a moral sense, his hands are filthy. According to the Tampa Bay Times, since 2005, there has been nearly 200 cases where the state's Stand Your Ground law has played a factor in prosecutors' decisions, jury acquittals, or judges' call to throw out the charges. Among these cases, defendants went free 70% of the time. Although Florida was the first state to enact a Stand Your Ground law, there are 24 other states that have enforced similar versions of the law. I will now discuss with you 5 cases that I feel are very significant in the subject of the Stand Your Ground law. The first case was in November of 2007. A man from Houston pulled out a shotgun and killed 2 men, whom he suspected of trespassing his neighbor's home. Joe Horn, a 61-year-old retiree, called 911 and urged the operator, "To catch these guys, will you? 'Cause I ain't gonna let them go." Those were Horn's words. Despite being warned to remain inside his home, Horn stated he would shoot, telling the operator, "I have a right to protect myself too, sir. The laws have been changed in this country since September the 1st, and you know it." 2 months earlier, the Texas legislature passed a Stand Your Ground law, removing a citizen's duty to retreat while in public places before using deadly force. In July 2008, a Harris County grand jury declined to indict Horn of any criminal charges. The second case took place in Louisiana. A grand jury cleared a 21-year-old Byron Thomas after he shot into an SUV filled with teenagers after an alleged marijuana transaction went wrong. One of the bullets struck and killed 15-year-old Tremonte Miles. Although the SUV was allegedly driving away when Thomas opened fire, Lefort Parish Sheriff Craig Weber said to local media that as far as Thomas knew, someone could have jumped out of the vehicle with a gun. Thomas said the sheriff had decided to stand his ground. Louisiana's Stand Your Ground law was enacted just a year after Florida introduced this law. In the third scenario, in March 2012, Bo Morrison was shot and killed by a homeowner in Wisconsin, who discovered the unarmed 20-year-old on his porch early one morning. According to friends, Morrison was trying to evade police responding to a noise complaint at a neighbor's underage drinking party. The homeowner, thinking Morrison was a burglar, was not charged by the local district attorney. While Wisconsin doesn't have a stand your ground law that extends to public spaces, Governor Scott Walker signed an intruders bill in 2011 that presumes somebody who uses deadly force against a trespasser in their home, business, or vehicle acted reasonably, whether or not the intruder was armed, before the law was enacted. Homeowners could only use deadly force if their own lives were at risk. In the fourth scenario, in April, a 22-year-old Cordell Jude shot and killed Daniel Atkins Jr., a pedestrian who walked in front of Jude's car just as Jude was pulling up to the window of a Taco Bell drive-thru in Arizona. Jude claimed Atkins had waved his arms in the air, wielding what Jude thought was a metal pipe. It was actually a dog leash. Jude shot the 29-year-old Atkins, who was mentally disabled, once in the chest. As of May, an arrest had not been made in the April 3rd shooting. Arizona passed a stand your ground law in 2010. In January, our fifth scenario, here in our own city, a judge in Miami tossed out a second-degree murder charge against Grayson Garcia after he chased a suspected burglar for more than a block and stabbed him to death. The judge decided the stabbing was justified because the burglar had swung a bag of stolen car radios at Garcia, an object that a medical examiner at a hearing testified could cause serious harm or death. The judge found Garcia was well within his rights to pursue the victim and demand the return of his property. I present these cases to you for one reason, being to demonstrate the massive spreading of the Stand Your Ground law, and another reason being to show that there is a difference between standing your ground and being given the will to kill. The most recent and familiar case concerning the Stand Your Ground law is the Trayvon Martin case. I have read and analyzed the case as well as many others. With the media given evidence, I can only reach one conclusion, and that is that a bag of Skittles and Arizona iced tea could never cause harm. And such a lightweight boy, in comparison to the armed neighborhood watch captain, there was no battle. Yes, Zimmerman has been charged with second-degree murder, but that does not bring a life back. Too many lives have been justifiably taken. There are too many cases in which it is a killer's voice against a dead man's. So, for those innocent dead men and women whose voices have been wrongly taken, this speech is for you. Thank you.